Good morning, everyone. My name is Jeff Kanige. I'm the editor of NJBIZ. Welcome to our discussion on workplace discrimination. This is an interesting time for a discussion like this, to say the least. On the one hand, the days have long since passed when complaints about harassment or discrimination at work could be ignored, swept under the rug, or worst of all, dealt with by firing the victim. On the other hand, businesses continue to find ways to get it wrong. Let's take the Houston Astros. They ignited a firestorm of criticism over their aggressively churlish reaction to some misbehavior by one of their executives after they clinched the pennant a couple weeks ago. They got it wrong, and getting it wrong can have severe consequences. Careers can be ruined. Reputations can be trashed. Entire organizations can end up looking like toxic pits of cruelty. This morning, we're going to talk about how to get it right, how to avoid complaints, or failing that, how to deal with them fairly and in a way that allows business to continue operating at a high level. Leading that discussion will be Cristina Amyot. She is the president and CEO of human resources consultancy EnformHR. The firm provides a wide range of HR services, including compliance audits, outsourcing, and training and development. Ms. Amyot earned a master's in human resources management from Rutgers University and holds a senior professional in human resources certification from the Human Resources Certification Institute. Please welcome Cristina Amyot.
Thank you. Oh, can I have that?
Yes.
Good morning, everyone. I can't tell you how excited I am to be moderating this because, as Jeff mentioned, our firm does do outsourced human resources, predominantly for businesses that aren't large enough to have HR. Some of them are, in which case we're going in to do investigations and trainings. And this is happening every day. We have over 200 clients, and it doesn't matter how professional they are, what industry they're in, how dedicated the employees are, how much managers care, this is happening. So I'm so thrilled to hear from our panel because they truly are experts in their industry. We have Howard Matalon, who's partner in employment practices and litigation from Olender Feldman. We have Kevin O'Connor, who's partner and co-chair of labor and employment practices from Peckar and Abramson. And we have Susan Carrero, who's president and director of HR from 7-Star HR, which is a division of Triton Benefits and HR Solutions. So I want to give them a moment to introduce themselves in their own words, and then I'll let you know specifically what we're going to be talking about today and get going on hearing from them. Go ahead.
Good morning, everybody, and it's a pleasure to be here. As she indicated, I'm a partner at Peckar and Abramson. We're a full-service law firm located throughout the country. We have about eight offices, I believe. 130 lawyers, and I'm the co-chair of the employment and labor practice.
Good morning, everyone. Howard Matalon. I'm the practice chair of our employment practices and litigation group at Olender Feldman, which is a small firm in Summit, New Jersey. We have 20 attorneys. I have a nationwide employment practice that specializes both on the management side and also in coaching executives through their crisis situations and their hiring and separation negotiations. Thank you for coming out today in this weather.
Good morning, folks. My name is Susan Carrero, and I am the founder and president of 7-Star Hospitality Resource, which is a division of Triton Benefits and HR Solutions. With 7-Star and Triton services small to medium-sized businesses to outsource all of their HR services, some with a PEO relationship, some without. Currently, I oversee about 5,000 worksite employees for our clients, and I am the open door policy. I am the place where the problems, the complaints come to, and I assist my clients in handling a claim or a worksite problem. So this is something I do every day, and I'd love to speak to it. So thanks for coming out.
So when I thought about today's agenda, I thought about talking first about what the root causes are of harassment and discrimination in the workplace, and then moving on to how we prevent it from happening. And then when the inevitable happens, as it sometimes does, how do we go about resolving it? So that's kind of how I figured we'd break this down. And the reason I wanted to start with the root cause, and I believe in one of our preparatory calls, it might have been Howard that had mentioned it. I think that's so important. You know, oftentimes you'll see managers and sometimes even HR people look to prescribe the cure to something, but they haven't diagnosed what the problem is. Where is this coming from? And I find it, very fascinating that in 2019 we're still having this discussion. So I wanted to turn to the panel to get their thoughts about what are the root causes you think of harassment and discrimination in the workplace.
So, Cristina, when we had that call, I think it was a week ago, I've been spending a lot of time thinking about the answer to that question, and it's so multifaceted. I mean, discrimination, I've been practicing almost 24 years next month, and I've seen the definition of discrimination grow. It has gone from, under our statute, the law against discrimination has been amended multiple times in the last 24 years. And things that when I started off, I came out of the military where certain things would happen and, I would see it. And then I came into the workforce and I would see it. And some things were acceptable 24 years ago. They are no longer acceptable, and rightfully so. The definition of discrimination has been broadened to protect people that weren't protected before. And I will say that it's also an economic issue in the sense that, and we'll get to this in a few moments, that I think the biggest threat to employers today is really claims of failure to accommodate disabilities, discrimination against persons based on their disabilities. And there are people in the workplace today who might not have been there had there not been a Great Recession, who are working well past the period where they thought they would be working. And that creates a whole bunch of issues for employers. So I don't think there's any one issue, and of course there's a astonishing lack of training sometimes on the part of HR. That's where these folks come in. Your companies provide a very useful service. A lack of EPLI insurance. EPL is key. If I can't emphasize enough today, if you don't have EPL insurance, get it. A lack of policies, a lack of consistency.
So this is my favorite topic to talk about. Root causes, right? The root causes of things. I personally don't think that workplace discrimination is root cause from anything. I think it's a byproduct. I think it's a byproduct of a vacuum of leadership in business. If you think about it, every business creates the problem. You're hiring people. They may not empower the problem. They may not be able to solve the problem, but it starts there. What are the criteria? What does it look like? Let's put the law to the side for a second. Tone-deaf leadership. Back-channel communications, where the employees are not talking directly to management about their problems anymore. People calling out sick on a more routine basis. The doors are always closed. And you talk about, at the beginning of this seminar, the individual who introduced everyone was talking about how, we're so much more savvy today and we know so much more and these things aren't happening with the same kind of frequency or in the same way. So I want to regale you guys with some quotes from an article that I picked up in the Huffington Post over the weekend. And these are quotes from a training seminar that was given by an accounting firm. Women's brains absorb information like pancakes soak up syrup, so it's hard for them to focus, the attendees were told. Men's brains are more like waffles. I don't know who in God's name puts it. Men's brains are more like waffles. They're better able to focus because the information collects in each little waffle square. Don't flaunt your body. Sexuality scrambles the mind for men and women. And for women, the invisible rules. Speak briefly. Calculate the number of people in the meeting and allocate an equivalent time for each person to speak. You often ramble and miss the point. Phrase your thoughts better. Wait your turn. And then the best part was a questionnaire they gave up called a masculine/feminine score sheet, where they rated the characteristics of men and women. So, for example, feminine qualities are affection, loving children, not using harsh language, and on the masculine side, acts as a leader, aggressive, ambitious. This was from 2018. This wasn't from 1953. And even if the company thought somehow they were trying to help solve the problem, who would do this? One of the top accounting firms, they no longer use this approach. The problem is that we're not solving for the root causes. We want to solve the problem. And by the time the problem has gotten to a complaint of discrimination in the workplace, it's too late. Now we're only solving for one individual when there's 499 other individuals who need the problem solved for them.
I agree. One of the main things that I see is that every employer has that harassment policy in the handbook, but it's right there in the handbook, and when they do employee orientation, they just care that the last page is signed, and whether the employee really understood what the policy was, whether the managers are making sure the policy is executed, just doesn't happen. So I see that most cases that I deal with is unintentional. It's insensitivity. It's just not knowing right from wrong. It's not knowing that that comment is inappropriate. It's management allowing the touching and the feeling and the inappropriate behaviors that they think is fun, it's social, it's a good thing. Well, it leads to that claim. It leads to that person may not even be involved directly. It's that indirect, person that feels, this is a terrible environment. This is something that bothers me. So it really starts from having that policy, having education classes, whether it's seminars, if it's a service industry, doing pre-shifts, having corrective action when someone does something wrong, having the dating policy, do you allow employees to date? Does it become inappropriate? It's fine when they're happy, but when they're mad at each other, what does it cause? Does it cause the possibility of someone feeling that now the workplace is unfair? They're being treated differently, some favoritism. So it's to me a lot of insensitivity. It's not understanding the life without having a policy, without having guidelines, without having rules, where these things can go. Many cases that I see starts with a friendship, starts with willingness that then turns a corner to a place that they didn't want to go, and they didn't say no, or they didn't stop it, and then it went too far, and then you have a case. So it's having provisions in the workplace of what's tolerated, what's not tolerated, educating your employees of what's right, what's wrong, what not to involve with. Social media has taken a toll to encourage so much more sexual interaction, joking, discriminatory comments or where your view, and then inviting your coworkers to be friends in that outlet has caused a lot of disgruntled issues in the workplace. So, and then of course the need for power, just competitive edge in the workplace causes that hostile environment. Someone trying to get ahead in their job, what's going to happen? You have to watch for the alienation of other employees, and that's pretty much it.
That's great. That's a great segue into, part B of my question, which is what does harassment discrimination look like in 2019? And I think about when my mother was coming up in the workforce, the biggest minority was a woman in the workforce or someone of color. And now if you look at, and the attorneys can speak to this, New Jersey LAD, I believe there are 18 protected classes. I could be wrong. And you'll have, as Susan mentioned, people say, we're a family here. And I say, oh, geez, I feel like my family. That's not a defense. So it's interesting because I'm curious. People tend to think that, harassment, discrimination is a racial slur, which it is, or it's somebody grabbing somebody inappropriately, which it is. But it's also so much more than that. And I think that's where some companies think, oh, this won't happen here. So I was hoping that the panel could talk a little bit about what you're seeing, and I think Kevin alluded to it with the ADA, in terms of what you're seeing in the workplace in terms of trends of harassment and discrimination.
Yeah, my practice is predominantly, it's all employer defense, but I do a lot of EPLI defense work. And I think disability discrimination, by and large, those claims constitute the greatest number. And you get you get a case with a stray comment, a racial comment or sexual comment. Those cases are relatively easy to resolve. If there's a legitimate claim of discrimination, those cases are pretty much resolved quickly, if there's an ability to do so. The cases that are more difficult to defend are the ones, and I think there's been some reference to that by Susan, and I did in my opening remarks, and that is when there's a lack of documentation. There's no policy on how to review people. There's no carrying out of the policy. There's no annual reviews for employees. There are no job descriptions for employees that are signed by the employees. So, as an example, I defended an airport operator, and this is a published case, so I can discuss it. And the gentleman who was in charge of the management of the airport had no job description that was signed by him. And as time went on, he was in the job for 7 years. He became wheelchair bound. And his job had historically required him to do a lot of physical walking and walk the boundaries of the airport, go up on the roof. But without that written job description signed by the employee, it was a hard case to defend. Now, the employer presented him with that job description while he was, there, and he refused to sign it and signed with protest. And ultimately, the case was defended, and I was able to get summary judgment. But that case took 2.5 years, and it went all the way to the court of New Jersey's intermediate level court. So, had the employer had a very clear job description from the inception, the case might not even have gotten off the ground. That's just one example. Harassment and discrimination today can be pay equity. I mean, New Jersey now has a new pay equity law as of April 2018, which all of you should be familiar with, which is not just geared toward ensuring that women are paid the same as men. It actually is the language of the statute protects anyone who's within any of those protected classes in the LAD. So conceivably, you could bring a pay equity claim and say the employer is not paying gay persons the same as they are persons who are heterosexual. So those are just a couple examples. But by and large, I think HR has to be better informed about disability discrimination, the importance of providing an accommodation, whatever it is that the employee is looking for. That interactive process is key, a good faith interactive process with an employee to determine what they're looking for. And we go the extra mile with our clients. We do a lot of counseling, and sometimes HRs, they want to pull the trigger and say, let's terminate. And I say, you know what, let's take another look at this. Maybe we can find another job for this person. Maybe we can go back to their physician and say, if we offered them this position, less pay, but this position here will be a good fit. And sometimes the employee takes it and you avert a claim. So I think that's enough out of me.
So what I'm seeing in my practice in terms of discrimination cases these days are harassment and gender and age discrimination. If you look around this room, pretty much everyone here is in a protected class, whether they know it or not. The average age of American workers now is 39, so we're almost all in a protected age class. Discrimination is very insidious when it comes in the pay area because the individuals assume that they have a right to sue if they're being let go for any reason. And the employer doesn't help itself when it terminates 10 people and 9 of them are 50 or older. The problem we have with discrimination is that just about everything in this country is now discriminatory one way or another. But let's be honest, as human beings, we use bias filters every single day. We use them when we wake up in the morning and look at our kids and they're not putting the right clothes on, right? So we filter things as human beings through our own prism. The problem is where we project that prism in the workplace. We treat people like objects rather than as assets. And let's remember that unlike any other capital asset in your business, the human being is the only one that is capable of doing one unique thing, which is appreciating in value. Every other asset will depreciate, right? From the moment that you take a car off the lot, it begins to depreciate in value. But the moment you hire an employee, you can actually raise them up. You can get more of a return on investment out of them if you treat them properly. And you do that, as Kevin well put, you create position descriptions. Then you go one better, which no one does anymore. You actually create KPIs or key performance indicators for those individuals. What do you want them to shoot for? And if you can't tell them as an employer what to shoot for, imagine what they're thinking. What are they aspiring to in the workplace? You create 360 performance reviews. What does that say? It says that you want their feedback. As much as you want to tell them what you think of their performance, you want them to know you actually care what they think about you. And when you're handling those separation issues, you better make sure that you have, if it's a reduction in force, that you think carefully about every single person and you comply with the Age Discrimination Employment Act and the Older Workers Benefits Protection Act so that you are actually identifying, if necessary, all the other workers by title and age as required if you're terminating 2 or more over the age of 40, so that when the person takes a look at the documentation, they say, this was fair or looks fair, or better yet, when they bring it to a plaintiff's attorney, which you know they will do. Everyone knows an attorney, right? The attorney will say you have no case. That's what you want them to say. Put yourself in that perspective. I want this person to believe, honestly, that we treated them fairly. Because the alternative to every American worker today is discrimination. I wasn't given a performance review every 6 months. The first time I'm finding out that you don't like my performance is at the end of the year. You hire me in January. My boss says I'm doing great things, but by November, I'm terrible. There's been no feedback. There's been no discussion. Well, what happened? Clearly, discrimination happened because I haven't been told anything to the contrary. And now I'm going to start thinking about all the things my manager might have said or done. Well, one day he said something about what I was wearing. And one day he made this off-color joke. Was it discrimination? No. But it becomes a case. And in the vacuum of leadership, all things are possible, discrimination cases being among them.
Having, to spin off right for where he left off, having a tolerance for inapt performance definitely makes it difficult when that employee just final straw. I want to get rid of him now. I want to get rid of her now. That's it. She showed up late for work. Well, what else? Name 20 things they do wrong. Did you communicate that to them? Did you talk to them? Did you write them up? Do they know that's wrong? How many other people in the workplace do you allow to come in 10 minutes late or 30 minutes late? So if you're going to terminate for that, are you discriminating? Are you just picking on this one individual? Many employers that work with me want to terminate quickly. I look at past performance. Did you communicate? Was it addressed? Who else is doing it? Are you being consistent? Communicating performance reviews, critical. Having accommodate, the number one thing that, in addition to that I face is employers not understanding how to handle an employee going out on leave, whether it's maternity leave, whether they're seeking cancer treatment, but they're still working part-time. Employers' lack of understanding on FMLA, how to start the ADA process. I have seen more and more cases Do I cancel their benefits? Do I not have to pay employer benefits? This is where I'm seeing lots of employees filing claims against their employer because the employer did not understand that they were under a protective status. They didn't understand the key words. You know, I'm going through something. I'm going out for a week. I'm going to rehab for a week. And employee comes back and, you know, the employer has a gun to their head. No. You knew that. They're now going for treatment. You need to understand what's the ADA process, how to start it. So many incidents will occur, and it's someone who already made you aware that they have a problem. You already were accommodating them without making it official. So to go terminate that person now for that reason, or because they're missing a lot of work, or because they're not communicating, or they're no longer available, you have an issue. So to me, that's one of the things that I face most often, and it's understanding the state and federal leave laws, what's out there for the employee, communicating it, writing letters to the employee, letting them know that we are willing to accommodate this. When that changes, if it's an inconvenience, or if it's a financial stress on the business, what can you do about it? Can you tell that employee, like, I can't accommodate this anymore? Understanding that not to have those types of cases. But I deal with those most often.
Susan, you brought up an excellent point about when an employer knows about something. So, and a lot of businesses I work with, they think they need kind of a dossier delivered to them that actually says this is an official complaint, or I need this official leave. And you bring up a good point about someone saying to an employer, hey, I need to be out a week. Can we talk a little bit about what the onus is then on the employer to engage in that interactive process? And also, same thing when it comes to a complaint regarding harassment, discrimination. It's not necessarily somebody walking into HR with an attorney in a briefcase. You know, what does that look like? What do complaints look like in real life, so that you all know how to recognize that? Yeah, why not?
Okay. So I like to go right to the complaint process. Number one, have an open door policy. Make it very clear. Have that safe place for your employees to go to, where they really feel it's a non-biased person that's going to listen. And it could be an email, it could be a 5-minute conversation, but at the end of the day, document it. Send an email back to that employee thanking them for using the open door. Send them a form to fill out. Say, please, let me know what happened. List details, any witnesses. And the number one question, what is your requested relief? What are you looking for? Can you not work with that person anymore? Or you just want it to stop? Or, well, I really want to raise, or whatever it may be, you know how to attack this. And within, 24 hours of that person coming to you, you need to communicate. Because within 24 hours of them talking to you, they're going to talk to everybody. Mm-hmm. They're going to communicate it through the workplace. They're going to go to their spouse, their friends, a neighbor or attorney. So you need to jump on it quickly. In regards to an employer, having any acknowledgement of your medical treatment. Number one, cannot ask a lot of questions, but if somebody asks for an accommodation, you know that they're seeking medical treatment, you can ask for the accommodation to be put in writing. Please have your medical provider let us know what you need. Once you are aware, then you need to handle that employee very carefully. You need to document the accommodation. You need to make sure it's updated. If it changes, you must be notified. But if you are looking to terminate because someone's no longer reliable or they don't have a lot of energy, think twice, because you have now started the ADA process without officially calling it that. You've allowed that accommodation.
So let me add to those excellent points. First of all, we talk about HR. If your HR professional in your business is just hanging posters, you've wasted a whole bunch of money. They are the lifeblood of the organization. They should be the first resource. An open door is not only for HR. Most good businesses have mentoring programs as well. There are people designated within the organization who want to hear the complaints within the workplace. Let them be heard. And by the way, let every single complaint be treated as seriously as a lawyer sending the company a letter that says, my client is the victim of discrimination. And the best thing I heard is, what do they want? What do they actually want? Most employees want a fair shake. Problem with small businesses is the inability of the business to solve for the problem. You have a 3 or 4 person business, the person reports to the owner and the owner is accused of the discrimination. What do you do in that situation? And the immediate solution for the business shouldn't be, well, obviously that person has to leave, don't they? Why? You hired them. You have a responsibility to them. The solution a lot of times is actually to hire an outside HR professional or an investigation group to come in and do a fair and impartial investigation. The impartiality investigation is as important as documenting the complaint and listening to the person who is suggesting that there is something wrong within the workplace, whether a toxic work environment or something more directed at an individual. If you take those types of concerns seriously, you will find that you are more likely to get resolution with the individual, and it won't result in some kind of a investigation that leads ultimately to litigation and then getting your EPLI carrier involved. And while I love dearly to have EPLI coverage, let's remember that the insurance carrier is only a backstop. It's not the first line of defense. You guys are the first line of defense for your business.
The only thing I'm going to add to some excellent observations, I've seen many cases that come in the door where the employee never followed any procedure. They never made a complaint of harassment or discrimination when they were there. They only did that after the fact. They did that after they were terminated. They went to a lawyer, and then you get the letter, 3-page letter, and it says, I hereby demand $75,000. The only thing I would add to that is at that point, if that happens, be sure to tell your carrier if you have an EPL policy. Don't start digging around without a lawyer being involved. And I've seen HR sometimes start writing emails. Hey, Joe, look at this letter. Did any of this happen? And, or Nancy, Joe, and write it to a couple of different witnesses. You start getting emails back. Mm-hmm. You don't want to create evidence because what will happen is once the litigation starts, then those emails will be evidence. They will be turned over, and that will increase the demand that the plaintiff is making if someone responds, well, yeah, he kind of was rude to her, and I think he might have said X, Y, Z. But of course, if you have a situation where someone makes a claim while they're still employed by you, your point is well taken. I mean, I represent a lot of companies that don't have the wherewithal, some nonprofits, some government agencies, they don't even have the wherewithal to hire an outside firm to come in and do an investigation. I mean, it's a $30,000 expenditure, or it could be. Just make sure you assign it to someone who is knowledgeable of the requirements, is knowledgeable about how to do an investigation, and then whatever you do, don't let the purported or the alleged wrongdoer participate in the ultimate decision.
So I have a couple other questions about prevention, but I think I can go back to those because since we started going down the road of resolution, I want to stay on this because I firmly believe that a botched investigation is one of the worst things that can happen. It makes the culture and the climate for employees that much worse. It has long-term ramifications where the other employees feel like, well, you can't go to HR because look what just happened. And you clearly are just handing over a court case to the employee. So maybe if we can skip to that and talk about what you do from the moment that complaint comes in.
So number one, when the complaint comes in, listen. You have to be a good listener. Do not interrupt them. Try to get everything. Let them know that this is confidential and it's on a need-to-know basis only. That's how you're going to treat it, and you're going to request that that employee treats it as well. When you do an investigation, you have your witnesses or employees, random employees that you pick to ask questions, sign a witness statement that also is a statement of confidentiality. The worst thing is that the entire staff starts talking about it, and that's where it can go down the wrong path. That person who was already feeling insecure or upset is now twice as upset because everyone knows about it. Be very careful on using the person who reported's name in the investigation. Just make it random. Have you witnessed any form of harassment? Has anyone mistreated you? Have you witnessed anyone mistreating someone else? Whatever it may be, make it random. Always follow up constant communications to the person who complained. Let them know where the process stands. If you suspend someone because they are the accused person, let them know where that person stands. You will have a right to speak, tell us your side, and let them know where it goes. In investigation, it could be a 7-day suspension, could lead to 3 weeks. It may take you that long to make a determination or to fix the problem or to determine all the parties involved, but keep the communications channels open. Remember to continue to preach confidentiality.
So if the complaint comes in and the first question that the person asks is, I didn't really know what our policies or procedures are, you've already hurt yourself. All handbooks today have to have a documented process or procedure for handling grievances. The good ones actually specify the difference between a generalized complaint and a specific workplace grievance. You want to identify who within the organization is going to receive the complaints, who is going to investigate the complaints, what does the process look like? And that ultimately serves to be the script for the person who is talking to the individual who is claiming that there's some type of problem within the workplace. All of that's critical because under New Jersey law, under the law against discrimination, if you want to raise as a defense that you had a policy or a procedure in place that the individual didn't follow, they just decided to sue you, and you haven't documented the policy, you will not have that defense. And what did it cost? About $3 to put that together? Come on, we all have to look first to the documentation in our hiring processes in order to make this process work effectively. Once you have that in place, I agree, confidentiality is important, but let me qualify that. The confidentiality that an individual has in an investigation is not the same as, let's say, the attorney-client privilege, where you hire an attorney and you know the attorney will never say anything you tell them, and it's your privilege. In this case, when the grievant comes to the company and says, I have a complaint, I'm really afraid, I don't want anyone to retaliate against me, what assurances can you give me that management won't find out about my complaint? Well, the answer is none, because the whole point is that the company needs to effectively investigate it. What you can say is that the confidentiality is qualified. If it's about a certain person within the organization, you're not going to identify that person to the organization unless it is necessary for you to complete the investigation. There are some situations where, remember, the accused also has rights. It's not just about the accuser. There are many, many cases that were filed after Me Too by men suggesting that the companies just railroaded them out without due process. Equal problem for the business, right? If you don't treat everyone fairly and give them all due process, someone's going to complain. It's human nature. So you want to let the person know that to the extent you can give them confidentiality, what they tell you, you will. But it's not a guarantee. It's not absolute. Once you get through the confidentiality process, you want to make sure that you objectively determine who the witnesses are. Get all of the facts. Do not place a filter, your own filter. It's one of the great things you learn in HR. It's why I took my own HR certification, because I wanted to see how the other half lived, so to speak. And it was interesting when I started talking to HR professionals and I told them that I had my certification. They said, finally, someone who can speak Italian. Mm-hmm. And it's because of what I didn't know. I mean, remember that lawyers have rules to follow. We have case law. We have courts. We have other guidance references. What does HR have? This. And that's about it. They are the front line. They are actually the fact gatherers in many cases. And that can be a horror show for the HR professional who's not prepared for a full-blown investigation. You want to make sure that you've dotted your I's, you've gone through every potential witness who might have something to say about this, and you have to talk to them about confidentiality. Many situations come up for everyone on the panel where someone says, oh, I know all about what happened, but I don't want to say anything. Why? Because I know the individual, and my job is more important to me. We have to break those cycles in this country, because otherwise no one will report. It will continue the same dynamic within the organization of that toxic culture where nothing is resolved, nothing happens, and there's no point in actually reporting a complaint of workplace harassment or toxic work environment, because all that will happen is the individual will either be forced to leave or leave on their own.
I'll just add excellent comments. I mean, the only thing I'd add to it is identifying an actual complaint is very hard because, in my experience, it's rare. Maybe 1/10 of the time, the employee actually made a written complaint through the process. Most of the time, it's in litigation. They'll allege, I told the assistant HR director, she's my friend. We texted each other and I told her. Or, I mentioned it to one of my coworkers. So that's where training comes in. Training your managers to identify what is a complaint. Complaint isn't necessarily filling out a form. It can be just someone expressing their concerns. And, training is so inexpensive in the grand scheme of things. I mean, a case that I handle could range anywhere from, $5,000 to defend to, $500,000. There are cases that go on for 5 years that cost $500,000. No exaggeration. It's easy. Even at reduced rates with an EPL carrier, if you got a law firm on the other side representing a plaintiff who has no intention of settling with you, you're going for the ride. So training is absolutely essential.
I just want to say that I have a client that won a discrimination lawsuit, and it cost them over $1 million in attorney's fees. And that's not lost productivity, travel of executives, and morale. So it is definitely damaging. And Kevin, you brought us right to the point where I want to be, which is back to prevention and training. So as the panel knows, and as probably most of you know, there are only a few states, New York, California, I might be missing one other, Connecticut, that mandate training, and it's specifically sexual harassment training. And we know that there's a lot more that people are discriminated against, not just sex. It could be gender identity. It could be race, color, religion, national origin. I mean, I could go on and on and on. So, and I'm sure you've heard from companies, well, I don't want to have training because I don't want to open a can of worms. And I'm thinking to myself, so you've got a can of worms. And at some point, the lid's going to pop up. So I'd like the panel to talk about training and what their thoughts of it, and specifically state law versus best practices, because I doubt any of you say, oh, yeah, we've got race and religion and all that covered. We'll just do sexual harassment training.
I mean, I have an associate who works for me who has been training people now for, I think, 3 weeks straight, 7-8 hours a day in New York. Employers in New York are taking it very seriously. And it's not expensive. I mean, you negotiate a flat rate to do it at a reduced hourly rate. You're talking about a couple grand to train your people versus if you have an EPL policy, you probably have a self-insured retention of $25,000 for one claim, or maybe less, maybe more, depending on who you are. So think about that.
Yeah, I would say these days what's interesting is it appears that the legislatures around the country are beginning to listen to what's happening in the world of employment law, so that sexual harassment training, which was a best practice that most of our firms were recommending years ago, is now being codified into law. We will see New Jersey pick that trend. I mean, when the governor took office, he indicated that he wanted New Jersey to be the mirror image of California, and he's getting his way in a lot of different respects. So I think sexual harassment training will be here within 2 years. Start now. There are actually a number of ways of handling that kind of training program that don't require live training. There are a number of really well-established online courses, some that are actually sponsored by law firms that have their own sister companies. There's a company called Shift, which is a spinoff of a law firm called McFreeman, and they have a phenomenal online training course that is tailored by state. Some states will require a certain number of hours of training to be done, and there'll be time training. The great part about using online programs is you get only a report that the person completed the training. And the best online courses will actually challenge your thinking, not only about workplace harassment, but unconscious bias, innocent bystander training. They're all intended to get you to shift your thinking about the problem of workplace harassment and discrimination, and not only in those areas, but sensitivity training, another great area. All of these kind of training protocols can be brought on by third-party professionals. HR companies have them as a staple of what they do, and I would encourage everyone to reach out and grab your friends and put those training programs on, and put them on at least once a year. Eventually that will be mandated, sometimes twice a year, depending upon how many new employees are coming in, because remember, that's the constant problem, right? You train one day, you hire 30 people in March of the following year, and now they have to wait until December for training. That's a long time. And that's usually when the problems happen. It's a failure to be aware of the problem that usually leads to discrimination.
So I'm coming off of a very long road trip of training because Connecticut and New York recently adopted some changes to their policy, and the timeline was the end of October. I like to call it sensitivity training because it blankets everything that can happen in the workforce. It's not just sexual. Bullying, intimidation, hostile environment, much more popular and common. I do understand the comment. I don't want to open a can of worms. So I like to have the core training for all employees, but then there's a different level for leadership. Because the leadership, you have to make sure it's not happening. You want to send the awareness to all the employees, but the leadership needs to take it a step further. And especially, they cannot act that way. They cannot have favoritism. They cannot say an inappropriate comment because it escalates. That's my manager. If my manager acts like that, it's more likely to affect an employee than a coworker. So that's what I would like to add.
That's great. I have a couple other questions before we open up to Q&A. I want to talk briefly about joint employment. So some of you in the audience might have a PEO, some of you might be a franchisee, and so I wanted to talk about, who's responsible in those situations for ensuring a workplace that's free from harassment and discrimination.
I'm a geek and I love this topic. I write a lot about this, and it's a huge issue, particularly as you have more PEOs out there, and I know Susan could talk about what a PEO is. You have the growth of franchises in this country is enormous. So as you have more and more franchisee relationships, you have a lot more claims being made by employees against both the franchisee and the franchisor. You take any hospital, you take this hotel and walk around, and if you were to actually sit and talk to some of the people that are here, you'd find that they're employed by different agencies, different entities. People who are working in the kitchen might be employed by one company. Somebody who's cleaning the rooms is employed yet by another. And the hotel is likely owned by a franchisee. So joint employer is a big issue in my field right now, and there are things you can do to protect yourself from being brought in on a claim. That would take another hour and a half to go over.
I would add to Kevin's excellent points that when you're dealing with joint employer, usually for most employers in New Jersey, it would involve some kind of issue involving a PEO if you have them as part of your health care benefits and HR. Read the print carefully. Some of the PEOs will actually indicate that they are not responsible for certain things. Some of the PEOs will actually take certain responsibilities on their shoulders, and that's also important because if you don't comply with the PEO agreement, you are actually running the risk of losing some of the coverage and benefits that they offer your businesses. So don't treat them flippantly as if, well, fine, they're a benefits provider, but we don't really use them for HR. Then God forbid the problem arises. You don't follow it, and the PEO rightly comes back and says, we're not covering this. This isn't part of our EPLI that you've acquired, or this isn't part of the benefits we provide, because from the moment that the complaint came in, you were required to report it to us by agreement. So I would just caution everyone that's working with a PEO to really better understand the relationship you have with them, because they can be extremely rewarding if you understand the dynamics in that relationship itself.
I'll be honest with you, 10 years ago, I thought the word PEO was a bad word. And in founding my company, I wanted to make it a positive. I wanted to not make a PEO just gouge me for money so that I could save money on workers' comp or health benefits. I opened a PEO that's a partner in being part of your employees' lives, making them feel that you're a much bigger company than you are, that you have benefits that the competitive company down the road cannot offer, that there is a place for support. I partner with my clients. I help them make decisions. I make it with them. If you have a good PEO, definitely look at the contract. There are areas where I'd like to not be liable if a client sexually harasses one of their employees. I don't want to go to jail with them. But obviously I have I have insurance as well, and my insurance is twice as much as the client's insurance because technically I can be brought in to anything any of the worksite employees do. But you can find, whether it's a franchise group or an HR company or a co-employment relationship, where you can partner with them and have them help you create policies and create a good work environment.
So at this point, I want to open it up to Q&A. And in the interest of time, so we can get in as many questions as possible, and also confidentiality. Remember, we're being recorded. So when you get up, if you could say just your name, your company, and your question. We don't want to get into too many specifics. The panel will be here afterwards, too, if you do want to come up and engage them on some very specific questions. But we want to keep it kind of general and not get into too much background on your company, just name, company, and question. So we have someone going around the room. If anyone has a question for the panel, raise your hand, or I'll keep talking.
My name is Michelle Josias. I am with UBS Financial, and really a general question, but in the absence or in the presence of handbook job descriptions, key performance indicators, how does a performance improvement plan work in both those scenarios?
It's a good question.
Very good.
That's a really good question. It doesn't, because if there's no floor, then how do you know what the ceiling is, right? So the whole point is to take someone's performance up a notch. The hard thing that you have in that position is you would have to bake it into the PIP itself. So, for example, instead of a PIP saying, obviously you're not meeting your criteria that have been specified, now you have to say, you have to actually document. On X date, we talked to you about this problem. On Y date, this happened. On Z date, this other thing happened. As you know, these things, are contradictory to our policy or contradictory to the manner in which we expect the job to be performed. Therefore, we are now asking you to add these criteria into the next 60 days of your professional history here, and we'll then evaluate again. But yes, for everyone who doesn't know how a performance improvement policy works, this is an interim step of discipline. It is a form of discipline. It can be construed as an adverse employment action, so it's very important for everyone to get them right. If there is no job description or position description or criteria for the individual to follow, they are rightly going to claim, when you all of a sudden present them out of the blue with a document that says, if your performance doesn't improve within 90 days, we're going to possibly let you go, the first question that they're going to ask is, what was I supposed to do? Isn't it human nature? And so having the documented process at a minimum, and look, you need job descriptions for a whole host of reasons, right? We all know that, for example, for overtime compliance, if we want to find out actually whether you're potentially exempt from overtime, we need to have a job description that meets any of the Department of Labor criteria for overtime. That's one reason. Another reason is, God forbid you actually get into a discrimination context and you're claiming that the person's performance is why you terminated them. Well, if there's no record as to what they were supposed to be doing, how are you going to terminate them for what they don't know? So this is, and I think Kevin is the one who first brought it up as the need to have them. Employment is a process-driven thing for all of us. And it starts with creating, in the hiring context, the right set of documents, including a job description. But if you are in the place where you're kind of an island and you haven't put any of that in place, the only way to do it is you're almost backdooring the job description into the PIP. It's the only thing you can do.
I'd just like to add that I'm a litigator, a trial attorney, so I get these cases when they're very advanced, and I'm going to put that way. And so if you don't have a policy in the workplace about who's even entitled to a PIP, like when is progressive discipline used, are there circumstances where you go right from the incident to termination? Is that defined? And if you don't have any job descriptions, it's a nightmare for the trial lawyer, because the claim is going to be made that you failed to adhere to any policy. You had no progressive discipline. The reason you did that was because you didn't like the color of the person's skin, or you didn't like their gender, or what have you. And in terms of discovery, let's say you have 100 employees and there's a claim that comes in like that where you don't have a job description. The plaintiff's counsel is going to say, I want the employment records for all of your employees. And you're like, well, wait, you should only get them for people in this particular job description. Well, how do I make that claim when there is no job description? Plaintiff's counsels are always going to look to broaden the scope of what it is they're looking for. My job is to keep it very narrow, because once they start getting into other employment files, who knows where that whole case is going to go. So it's all really tied together. I could go on for hours about best practices that could help me when I'm defending these claims. But again, without a policy, I just, you can do a PIP. And by the way, PIPs, a lot of times the employee will just say, I'm not signing that, Or this has things in here that says it's my job. That's not my job. That's Joe's job.
So after the 90-day orientation period, I commonly get at, the 120 days, I just want to fire this person. And there's been no warnings. It's performance-based. They're just not meeting performance. So we strongly suggest at that time to engage in a personal improvement, outlining what the expectation of the job was, where they're not meeting it, and really, really challenge with the goal to turn this employee around. Don't go into it, I'm just going to give them the PIP so that in 30 more days I can fire them. You really want to go into, give them that opportunity, give them that education, give them that feedback, and then see if they take it and become a rock star for you. So I promote them. I use them less from a disciplinary than more a tool to help save your job and help make maybe a weak manager or not so great educated manager become a better leader in communicating and sitting down. We help our clients write them so that it's making the employee and the manager communicate on the tools of the job. And we also encourage the employee to give open feedback. What do they need to do a better job? We usually put that in the PIP so that it becomes interactive.
Great.
Hi, I'm Sherry from Victim's Voice. So New Jersey has been becoming more startup friendly. And startups are a true mix of 1099s with very few employees at first. So if you have a situation where maybe a contractor who is on retainer works with you very closely on an ongoing basis, and you have some kind of issue with an employee who maybe works part-time with the company, how does all that complexity work out as far as reporting, process, all that? Because now you're introducing someone from the outside who isn't an employee, who necessarily has a job description, but you can't hold them like you can an employee.
I'll take this one.
Awesome. Thanks.
So,
I was hoping you would.
So all employers need to worry about third-party incidents, whether it's a customer, whether it's a vendor, whether it's a contractor. If there's any incident that involves a third party, you are responsible. So your policies, how you operate your company, how employees are treated, carry out to that third party.
I would start from the basic that those independent contractors might actually not be independent contractors under the law. But let's put that to the side. The more modern handbooks these days, while they'll differentiate between an independent contractor and employee on certain areas like benefits, et cetera, they make very clear that everyone is treated the same way from a workplace harassment standpoint. And that is probably the best advice I can give you on that point. Treat everyone exactly the same. It doesn't matter whether this person is part-time, full-time, 1099, seasonal, whatever their designation, that's just an employment classification. It has nothing to do with whether the law would recognize anything they do as a potential source of a claim.
Yeah, the only thing I'll add is misclassification is huge. It is a big risk for employers, and I write a lot about it. So, many, many times you get claims and someone says I was misclassified. They know enough what to lay out in the pleading, and they're going to get discovery. And, it's good. There's a good chance someone can prove that they've been misclassified.
It's more common to be a unicorn in New Jersey, right, than an actual. That's what I thought, yeah.
Yeah.
We have a question over there in the back. Yeah. Oh, shoot, sorry. And her next, sorry.
Good morning. My name is Jacqueline Miller, and I'm a former HR executive and now running my own company. My question is, and Susan, I know you mentioned something about sensitivity training, and in an effort to combat some of the workplace discrimination claims, I'm wondering what your approach or what your advice has been to some of your clients regarding conducting implicit bias training.
Part of the sensitivity training does have a section in regards to that. We blanket pretty much, in order to meet the criteria in New York and Connecticut of a 2-hour training, sensitivity training will cover everything. It will cover the new classes that you're unaware of on how to transgender identity, workplace incidents. In our training, we do a lot of role play. We do a lot of case study. We will show incidents that occurred, how they were tried. We will utilize a lot of examples of what's right and what's wrong and what's not acceptable behaviors. Through every section, we open up to employee feedback. We ask questions, which is great because it becomes very interactive, and that's where your staff really will learn a lot because they will ask questions of things that might be going on or that they're unsure of or how to handle a situation.
Good morning. My name is Keisha Feaster, and the name of my business is Labella Concierge Laundry Pickup and Delivery Service. But my question to you is, you stated, the panel, you stated that in the event that there are discrimination, that you have an open door policy, right? And then you also stated that in the event that it comes forth that they're training and stuff, a lot of times is the discrimination resolved? You're bringing awareness to the people, so are they clear on the action and stuff in which discrimination?
So with every situation, it may cause the employer to really open up a bigger awareness, not just for the incident that was reported, but for an awareness in the entire office, in the entire company. That's when you may engage in sensitivity training. You may engage in different management training. Obviously, through that investigation, you want to eliminate the problem. You want to get to the root of it. You're going to investigate it. You're going to find out how many other employees were affected by it, witnessed it. Is it a pattern of practice? And then you're going to game plan on how to conquer that. And various ways. After every incident, it is important for some employers will do a memo on everyone's next paycheck reminding everyone of the policy, of the harassment policy, of the discrimination policy. That's your first level to send that message immediately. Next, it could be having some, webinars or training sessions. It could be, inviting some of the managers to go out for a day of, leadership training that will have some HR content to it. Every company will conquer it differently, but number one, definitely identify the problem, who's affected by it, and then continue to train to make sure it's out of the business.
So a lot of times after, a lot of times after the training and stuff, the problem is actually resolved after all the training and stuff. Am I correct?
That's your ultimate goal. I mean, your ultimate goal is whatever the pattern of practice is that caused that incident,
Right.
whether it was something that you were allowed to do that created that feeling or that complaint. You want to eliminate it. You want to fix it so that it doesn't happen again. Especially if you are lucky enough to retain the employee. That's my ultimate goal, is to fix that problem. It could be a misunderstanding. Most cases that come to me are just uneducated, unintentional, inappropriate comments that just went too far. And if you can keep both employees, you can keep everybody, but you can fix it and they can become able to go back and be a great a team environment, then you've done your job.
I would add one other thing to that, which is training is part of an overall concept that we like to call creating safe spaces. Right? We're doing the training within the workplace because we actually want people to come forward and help the organization better itself by explaining the problems and the struggles that they've been through. Training, I've found in my experience, actually usually creates enough of a safe condition. You will actually find at the end of a training seminar, employees will come up and say, I felt like I was discriminated against, or this really resonates with me. They'll thank you for it, but be careful also that they may in fact bring or invite some complaints at that time. But that's a very healthy thing for the organization, because without it, they never would have come to you.
I would just add, sometimes as a result of that process, you determine that a manager just needs like charm school. You know what I mean? Really, it's like, Charles, you really can't talk down to everybody that way. They don't just talk down to women, it's just everybody. And the second thing is watch that supervisor, because sometimes there'll be a finding of no discrimination, no harassment. You got to watch that supervisor in the future, because that person may seek to retaliate. And it may be that there's an unfounded claim of harassment, but that person will have a claim if he or she faces discipline down the road, even if it's based on a complaint that was not upheld.
I'd like to add to all the HR professionals out here, biggest challenge ever is when the complaint is against the CEO, the person you work for. And where do you go? And when you have to communicate it to that person, are they going to retaliate? Are they going to do everything to get rid of that employee? Biggest challenge happens to me all the time.
Any other questions?
Hi, I'm Nira Nazareth with People First. Could you give us some insights on best practices for internal reporting procedures, both from mitigating corporate liability, but also from just the perspective of maximizing the value of the firm?
So I like to call the employment life cycle, it's in 4 phases, right? We have hiring, integration, retention, and elimination or separation. The integration and the retention phases are the worst. It's easy to hire, and it should be difficult to fire, although everyone says, fire fast, hire slow. The panelists have all, I think, outlined beautifully what the backstops look like. So you have the training, you have the employment practices liability insurance, you bring a PEO on to help manage the load for the organization because it's too top heavy, the managers are not paying attention. But there are other things that haven't been mentioned I think are very important. So if training is the only thing you're doing to bring your employees together, you're already failing, right? What benefits are you offering? Are you offering programs that engage the employees together? Are you doing any team building exercises? When was the last time the management team actually came out and had a town hall meeting with the employees? Never, right? We don't talk, we're all too busy. We don't have the time. We leave it to HR. Well, HR is leaving it to management, right? That's a management responsibility. The ultimate goal of HR is to be involved with change, the betterment of change. It's a leadership tool, and it's supposed to be used that way. But unfortunately, most businesses don't do anything with HR other than watching payroll and putting hiring policies together. That is 1/4 of the role of HR. So when you're asking for things that manager can do from a risk retention standpoint, get your policies, get your process together, but start engaging your employees. If you aren't, I guarantee if you were to send an anonymous survey out to your employee base and you ask them real questions as opposed to, are you happy in your job? You actually said, are you engaged in your job? Does your manager engage you in your job? You would actually find most of the employees would be dissatisfied. And dissatisfaction, by the way, with your job is one of the #1 problems in the country right now.
We have companies that will hire us to do exit interviews, which is awesome because they want like that third party that doesn't have any skin in the game, which is great. What always bothers me is they're not interviewing people before they quit. Why aren't you doing surveys while they're there to find out what's going on? And it may not be a harassment or discrimination claim. I mean, I think it was Kevin who said, charm school, this person could be not harassing and discriminating. They could just be a jerk altogether, but you still want them in the organization. And you're not finding that out until someone quits. So I feel like employers are missing the ball with that. Does the panel have any other comments on that? We have time for one more question.
I just wanted to add
Sure.
that you can do everything that we've told you to do, and you'll still have claims. I mean, it's a fact of life. And I've been around the block long enough. I'd probably seen, 4 or 5 economic cycles where the economy cools and the claims go way up. So I think there is some predictor of an economic slowdown in the next 12 months. So now would be a good time to get your house in order.
Especially before the holidays. I don't know about you guys, but I tend to terminate somebody around the holidays, not because I'm the Grinch, but because of what they did at the holiday party. I'm like, oh my gosh, it's kind of nice to set those expectations. Don't do that to Santa. We have time for one more question.
Hi, my name is Cindy Greif. I'm an HR business partner for a local healthcare system. I think it's just a quick question. If we have an employee come to us to bring, let's say, a sexual harassment complaint, and you'd like them to keep it confidential, how much can you push that or say, we are asking you or we would like you to keep this confidential because talking about workplace concerns is considered concerted activity. So how much can you push that? Is it mostly just saying, I would like to ask you, which is usually what I say, and I explain that I'm going to be meeting with the witnesses, I'm going to be asking them to keep it confidential as well. But it just, kind of always been a little, question how much you can push that. Because often they'll go back and they'll say, I just talked to Cindy, and this is what she said, and she's going to be meeting with other people, and then it's all around the department and through the hospital within, a couple of hours. So.
Yeah. It is a delicate balance. Regardless of what you tell them, in a lot of cases they won't do it anyway. I find that even when I go in and do an investigation after the fact, there's litigation, and I'm going in and I'm meeting with employees to interview them. I can't tell them to keep it confidential, and it's a complicated answer in the sense that there's now some recent amendments to the law against discrimination that pertain to confidentiality. The time it doesn't allow for us to go into that.
I would just add one other thing. We didn't really talk about the confidentiality when you're confronting the accused. Let's say the accused is a boss who's being accused of harassing his subordinates. It is absolutely necessary for that person to maintain confidentiality and not talk to the subordinates. And it's amazing how often the first thing the boss will do is reach out by text or email to the people that he works with and says, or she, and says, what do you know about this? I need to know everything. Come see me right away. And they should be fired for that.
I like to stress the confidentiality to protect their interest and to allow you to do your job. I also, if it does get out of hand and it does get through, I will write back to the employee reminding them that they have hindered the investigation, that, I understand that you were speaking to so-and-so employees. We're going to exclude them from witnesses because you influenced it. So I hit home, and again, the confidentiality is to protect them. They came to you because they're upset. And you just mentioning that, reminding them, if they want to talk about it, they can talk to their spouse, their sister, their mother, their friend outside the workplace.
So at this point, I want to open up to final panelist statements. Whoever wants to go first and just kind of sum up your thoughts for the day.
Just a recommendation, ask yourself before you want to fire somebody, terminate someone from employment, do I have enough to terminate them? And if you do, make sure you list everything, because you cannot use anything later if it's not in that termination letter. So make sure you have your facts. If they annoy you, if they're 10 minutes late, if they use inappropriate language, if they're constantly bullying others, list it in the termination. List everything, because number one, they'll know, wow, I really did a lot wrong, and I'm not going to go see a lawyer. Number two, they will know. Maybe they'll learn from it in their future employment. But you cannot use it later. If you did not use it at the time of termination, communicate it, you can't say, well, you really did this too. You really did this too later in court. Maybe you can back me up on that.
I mean, absolutely. What I would add to this is the following, that many times when we speak in these panels, we talk about protecting the business from liability. And what we're really saying is we want to protect the business from the employees. I think what we need to do to make a shift in this country is stop looking at it that way. We need to protect the employees for the benefit of the business. That's the one area that we could do an amazing amount of improvement with in this country, and actually look at the employee as the best asset we have. Treat them like assets rather than objects, and the business will thrive. There will be fewer complaints. There will be no discrimination claims filed. In very few cases will that ever occur. Treat them that way, and you'll actually see a remarkable and radical difference in your businesses.
I agree with everything you guys have just said, and I will say that I've seen some employers that I've defended over the years. They went from a slew of claims down to a trickle, and they did that through some of the very easy steps that we've talked about here. On Susan's point, I can't tell you how many times you get a case, and all of a sudden when the case gets filed in court, no one can agree who made the decision to terminate. It's like, oh, the CEO says, well, Joe told me to do it. And, that should be very clear in the mind of the HR person. Who is it that's recommending the termination? And because when you go to litigation, that is the single most picked apart area that the plaintiff's lawyers love to focus on, because it demonstrates circling of the wagons. It demonstrates that you're not willing to stand up for your decision. So when you're terminating, be sure that you have all the facts, as Susan said.
So at this point, I want to call Jeff back up to close the panel.
Thank you, Amy, and thank you, Kevin O'Connor, Howard Matalon, and Susan Carrero. As always, we'll have full coverage of today's discussion later today on NJBIZ.com, and expanded coverage in our next print edition, which is November 4th. In about a week or 10 days, we'll post a video of the entire event on our YouTube channel, so you can look for that. Kane AV is responsible for the video and for the sound today. Thank you to them. If you want more information about Kane, please stop by the registration desk. If you can, please join us at our next discussion. That's November 19th on health insurance right here at the Doubletree. I hope to see you there. Thanks for coming, everyone.